Business Association, it doesn't necessarily mean bad. What they do is they have to disclose it.
Yes.
And they should disclose, here are the costs. And you should be free to say, okay, what would it cost me if I were to use somebody else? Now, in Rhode Island, like I said before, you can choose your own title attorney. You can therefore have some say over who's doing what. A bank may say, well, this is who we want you to use for the appraisal or the this or the that, and I think they may be able to do that, but they need to tell you what the costs are, and then you should be able to go to another bank and say, well, if I use you, and what's your interest rate, and what are your fees for these types of things?
Sometimes people will shop around just for the cost of a loan, not just the interest rate, what the closing costs are going to be,
Right.
0 points, 2 points, 3. I've seen even higher on points. Why
Right.
people do that, I don't know.
But you should shop the whole package.
Exactly.
Because it is a whole package, and that's what RESPA is telling you. This is a package. The consumers use the whole idea is give us some transparency so that the consumer can compare apples to apples.
In the list of definitions in that special information booklet, it gives you a litany of definitions for the different type of loans that you can get. A balloon loan, a 30-year fix, an adjustable rate, an ARM. Some of these acronyms that they have for loans, I never even heard of.
Right. So you have, for housing loans, 15-year loans, 30-year loans, maybe 20, 25. So the term of the loan is going to affect what you pay. The interest rate is going to affect what you pay. If it's an adjustable rate mortgage, they have these different types of adjustable rate
5-year
mortgage.
ARM,
Right.
7-year
It
ARM.
can go up X number of percent points every 5 years, every year, every 3 years, whatever it is. You need to know exactly what it is that you're signing up for and what the effect will be next year or over the 30-year course of the loan. Those things are all very important.
I actually have a client who refinanced with, I don't want to name the bank or the credit union, but he refinanced, used some equity in his house to do some home repairs. During that time, he was also trying to settle some personal debt. It required him to refinance again, probably within a year or so. He gets to the table and he finds out you've got a prepayment penalty clause, so you got to write us a check for $27,000,
Right.
or we're going to take that off what the money that you're going to be getting.
Right.
And it put him further in debt.
Could he back out of it? It was a refinance?
Well, he really didn't understand what it was about. He could have backed out of
Yeah.
it, but he didn't because he needed to have a payment. Actually, there were taxes.
Right.
It was with the federal government. He had to get the federal government a
Right.
certain amount of money within a deadline or else.
Right.
And so he had no
He
choice.
should have contacted you before
He
he
should
did
have,
it.
yeah.
Would
yeah.
the disclosure forms already give him that information the day in advance so that he could have reviewed it? Or
What
that's
happened in this
different?
problem is he already had a note in place that had a prepayment penalty. You should always ask, too, is there a prepayment? Because you know how some people want to advance their payments by
Yes.
paying maybe
Some
twice a
kind of
month
principal
or
or whatever.
something?
Oh, even
That's
that.
what a prepayment penalty prohibits you from doing. What happens a lot of times, and I think they used to, I don't know if they still do with RIMFAC loans, because you were getting such a good rate and it's a first-time home buyer, penalty, there'd be a penalty if you sold it out within a certain period of time.
They
That-
needed to collect a certain amount of interest to make it worth their while.
That's
to keep
right.
Yeah.
Right.
Giving you that
So you
rate.
should know there's a prepayment penalty.
Yeah.
What about servicing? There are servicing costs involved with loans. Is that something that is disclosed at the time of application and then settlement, or are servicing fees levied later because they can, and what kind of consumer
That
recourse
should
is
be
there?
in your good faith estimate at the time you close the loan. If there is going to be another servicer, you have to be given written notice of that as well.
Right. And so there can be mistakes made as you're going through servicing. So perhaps you get a monthly statement and it says you're a month behind, or your payment is going up and it shouldn't be going up. If you have a problem with that, under the new RESPA Act, you can write to your servicer, your mortgage or bank company, and say, I've got a problem with this. And Jackie can tell you there are certain words you have to put in that letter, and it can't be on the coupon that you use to pay it.
That's a qualified written request. It's basically the individual borrower saying, you've done something to my loan that I don't agree with. If you're going to have a written request, what David was saying is you can't put it on a payment coupon, or don't put the written request in the envelope with your payment, because they often go
Yeah.
to different addresses. You want to write a detailed letter to the bank, and you want to detail as much as possible, be as specific as possible, every issue that needs to be investigated, every problem you have
Right.
with that loan, right down to the escrows.
Right, whatever the issue is, and you have to put those words in.
You have to.
Qualified written requests,
Yeah.
so they know that triggers certain things. They have to respond within a certain period of time.
Yeah, they have to respond within
10 or 20 days.
20 days, yeah.
And then they have to address what the issue is within 60 days. And during that 60-day period, they can't report to a credit agency if they think your loan is behind.
So you think that's a helpful consumer tip?
I call them RESPA demands. I've done them. I've done them in the past, RESPA demands, and that's exactly what it is, a qualified written request. You ask that the account be investigated. It's a lot of work for the bank. It's a lot of work, and if they don't comply with this, then you as the borrower can seek damages, I think up to $1,000. But I ask that the account be investigated. I ask for a payment history with explanations as to where each and every payment goes, that the credit rating be updated and corrected, again, notifying them that they're not allowed to report any negative credit within the 60 days. In some cases, maybe a title defect, that the title be restored, where certain fees have come from, like sometimes they'll do what's called a drive-by appraisal. People don't even know why they're being charged for things like that. As specific as possible, and that has to be responded to within a certain amount of time.
Now, that sounds quite comprehensive, Jackie.
It
Being
is.
a lawyer, I'm sure you understand that. Do most people, when they have that issue, do most people need to have a lawyer because they need to be that specific?
It is a
when it comes to-
complicated,
It is.
it is a complicated
seems it.
statement. It really is.
There's not a .com someplace, a Google
Yeah, I'm sure you
opportunity?
can do.
Yeah,
RESPA.
and you could probably, if it's a simple issue, just write it out as long as you use the words qualified written request.
There's a consumer tip.
Yeah, I mean, look in the
And you heard it at
statute.
Legal
It's
Matters?
right in the
Right.
statute. Just RESPA, Google RESPA, and then it's, I think it's section 6 of the statute, which is qualified written request. It's right there. Yeah, I don't think you have to be a rocket scientist, really,
No,
to write a
to do
letter,
that.
as long as you spell out what the problems are, because as we know, sometimes there is what I call negligent servicing of the loan.
Right.
Yes. So
Just trying to contact someone.
No, speaking of that,
Yeah.
it reminds me, I don't know if we have enough time for this quick story, but I had a client who had a loan that was with a bank, and the bank sold it to somebody, and she got a letter, you now have to pay us. She got a letter from another bank that said, now you have to pay us. So she came to me, she said, what do I do? I said, well, let's put the money in escrow, I'll write to both of them, and I'll explain to them that you now receive this notice from 2 different banks. What do I do? So I sent the letter out, and about 2 months later, she got a release of lien, taking the mortgage off that they had put on her house from one bank, and then she got the same thing from the other bank.
That's
so where
great.
did the money end up going?
Well, she ended up keeping the money, and my
good.
advice to her was sell the house. There's no lien on it.
That's a good idea.
I'm sure they would have caught on with that.
So
actually.
we've addressed most of the prophylactic or how to prevent issues. I hope we feel that there's going to be enough policing of this so that those new laws that are in place are actually enforced. We don't, God only knows.
Unless people
Comfortable with
speak
that?
up. Unless people speak up, how do you know it's going to be enforced, you know?
Well, we hope that some of these issues that we've addressed about the RESPA and loan servicing has been helpful to you. We encourage you to continue listening to, watching for some of these current topics that we'll continue to address. We thank you, Jackie and David, for covering this topic, and we hope you will stay tuned as we watch and stay alert for you about what issues are most likely to be affecting businesses and consumers today. If you have email requests and questions, please feel free to address us at It Was Legal Matters.
Great.
Thank you.